This is Bloomberg Law with June Grasso from Bloomberg Radio.
This is what happens when people have the best interest of our state in mind and work in good faith to come to a resolution.
Michael Madigan was an almost mythical figure in Illinois politics. His 3-decade reign earned him the nickname the Velvet Hammer because of the way he maintained power over decades of leading the state house and enforcing fealty from its members. But today, Madigan stands convicted of bribery, conspiracy, and fraud after a 4-month trial where he was accused of running a years-long criminal enterprise to enrich himself and his political allies. Prosecutors built their 4-month case on witnesses who turned state's evidence and wore wires, emails and documents, and wiretapped conversations like these.
If you can, get in your mind that your client is only Mike Madigan.
But I generally never refer to the speaker. I just say our friend. So if you just say our friend, no one really knows what we're talking about.
Speaker's office.
Hey, Micah.
Hey.
Will you tell the speaker I took care of Barrios and Peñanovich? Did you just throw away that note?
The trial may be over and Madigan's 7.5-year sentence handed down, but it's just the beginning of an appellate process that could have real consequences for corruption cases. Joining me is former federal prosecutor Mark Chutkow, a partner at Dykema Gossett. Mark, for those who aren't familiar with Illinois politics, tell us a little about Madigan.
Michael Madigan was the longtime Speaker of the House, a Democrat in the state of Illinois, actually the longest-serving state speaker in the history of the United States, having served for 36 years. He resigned office in approximately 2021 because of scrutiny by the federal government in connection with corruption allegations.
And a 4-month trial ended in a split verdict. Tell us about the trial and the verdict.
Well, in the trial itself, the jury threw out the racketeering conspiracy charges, also had some difficulty on some of the other bribery counts, but ultimately ended up convicting of 10 counts, including some of the bribery counts.
He has to report to prison on October 13th. I'm curious as to why the judge didn't allow him to remain out of prison pending appeal.
He filed a motion for release pending appeal, which are generally disfavored in cases like this. He would have had to have shown that there were substantial questions of law or fact that would have resulted in a reversal or a new trial for the charges for which he was sentenced to prison. The judge on Friday issued a 44-page order denying that motion, indicating that, at least in the judge's mind, there was no question but that he had committed these crimes, the evidence was there, and at least the judge was somewhat dismissive over some of his legal challenges.
So one of his likely arguments on appeal, which was previewed in the motion, centers on the definition of corruptly in the federal bribery statute. Will you explain this debate over that word, corruptly?
Yeah, the statute itself, Title 18, Section 666, which is a federal theft and bribery statute, specifically uses the term corruptly in connection with obtaining something of value in exchange for an official act or being influenced in connection with an official duty. And the term has never been ruled upon by the Supreme Court, although in a recent case last year involving a Portage, Indiana mayor named James Snyder, there was healthy debate within the oral argument about what the term corruptly means. And generally the Supreme Court is wary of vague terms, especially in the criminal law, and there has been a trend recently towards them ratcheting back on the scope of the prosecutors and the government use of corruption statutes. And so that seems to be the highlight here of what Madigan and perhaps the other ComEd 4 defendants are going to argue, that corruptly is a vague, unconstitutionally vague term that doesn't give fair notice to a defendant, to a public official, of where the right line is.
The Supreme Court, as you mentioned, has been cutting back on the reach of federal corruption laws and prosecutorial discretion to bring charges against government officials in a string of cases in the last decade. Can you sort of trace that out for us?
Yeah, it really started, especially over the last decade, in the U.S. v. McDonald case involving a Virginia governor, McDonald, who was convicted of various bribery charges, which were overturned at the Supreme Court based on what the definition of an official act is. In that case, the Virginia governor was lending his public space, the governor's mansion, to a backer of his who had been providing him items of value both to him and his wife. This was a nutritional supplement company, and the governor was making access so that this nutritional supplement company could have meetings with officials at the University of Virginia hoping to get contracts. And while the court said that that might be in some ways an abuse of power, it was not an official act. It wasn't a core duty of the governor to provide this sort of service. And so that case was struck down. Following that, in 2020, in what has been known as the Bridgegate case, Kelly versus the United States, the Supreme Court again overturned convictions of two former New Jersey public officials that had admittedly abused their power by realigning toll lanes as political retribution. But the court there said that did not fit under the mail wire fraud statute because there had been no money or property that had been obtained in connection with that case. Then just a couple of years ago, in a couple of cases, Supreme Court in a case called Percoco and another one called Simonelli also narrowed the scope of the term intangible right of honest services as unconstitutionally vague. And in a bid rigging case, scaled back the understanding that the government had been using in bid rigging cases to say that withholding information from a competitor is not a traditional property interest under wire fraud. Finally, this culminated last year in 2024 in the case I alluded to before involving this Portage, Indiana mayor, James Snyder, where the court said that under the 666 bribery statute, you cannot criminalize after-the-fact gratuities or rewards to a public official for positive actions on behalf of a developer.
Of the decade of Supreme Court decisions in these public corruption cases, I found that Snyder decision stunning because it seemed like a textbook example of kickbacks. He got the $13,000 after a trucking company was awarded city contracts.
Yeah, I mean, it certainly is what we call in the criminal parlance slime, but was it crime? The court looked at the statute itself and compared the 666 bribery statute with comparable federal statutes when federal officials engage in bribery and corruption, and said that it simply did not match the gratuity statute, which criminalizes after-the-fact rewards. And what the court was looking for was a traditional in-advance understanding by both parties that there was going to be a quid pro quo, a this for that transaction of thing of value for official act.
Court said a contrary ruling had the potential to criminalize commonplace gratuities like a Dunkin' Donuts gift card, a Chipotle dinner, or tickets to a Hoosiers game. And that was a 6-3 decision down ideological lines. Justice Ketanji Brown Jackson wrote for the liberals and said, Snyder is absurd and a textual reading of the statute is one only today's court could love. Do you have any inkling as to why, the Supreme Court has been cutting back on these public corruption prosecutions?
Some of it may have to do with federalism concerns that the court does not want to see the federal government micromanaging how state and local officials conduct their campaigns or interact with the public. Some of it has to do with fair notice. The government has been very aggressive, or had been very aggressive 10, 15 years ago, in asserting an intangible right to honest services and other sorts of theories to basically try to look at criminal or corruption activity within the state and local level. And at some point, the court thought that was overstretched, that it was giving too much discretion to prosecutors to import their own principles as to what good governance means.
And Madigan has hired as his appellate lawyers a team that includes the lawyers who successfully argued that Snyder case, indicating that he may be aiming for the Supreme Court.
Yeah, that's right. Lisa Blatt and another woman by the name of Amy Zaharia, who successfully argued in the Supreme Court last year that Snyder, his conviction should be overturned.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with former federal prosecutor Mark Chutkow. We'll talk about possible issues for Madigan's appeal and how difficult it is for prosecutors to bring public corruption cases these days. I'm June Grasso, and you're listening to Bloomberg. I've been talking to former federal prosecutor Mark Chutkow about the Michael Madigan corruption case, which may offer the Supreme Court a chance to redefine bribery law again. Madigan's appellate brief hasn't been filed yet, but that motion, which was unsuccessful to stay out of custody pending appeal, offers a preview of some of the likely arguments. And as far as that word corruptly, are they just saying that there should have been a different jury instruction?
They're saying that it just simply was vague. I mean, as the instruction looks right now in the Madigan case, corruptly simply means that a defendant acts with the understanding that something of value is to be offered or given to reward or influence someone in connection with their official duties. And so there was no specific definition of corruptly, although I must say that in the Snyder oral argument, it was debated quite a bit. In fact, the government in Snyder in oral argument suggested that corruptly might mean wrongful or consciousness of wrongdoing. They also alluded to an Arthur Anderson Supreme Court case where corruptly had been defined as immoral or inherently wrongful. Some of the justices pushed back on that as not really guidance at all, that there are no real clear rules to guide public sector officials if that's what you're going to be looking at. And so in this case, what Madigan has seized upon is that corruptly must mean something, and he is concluding that it means consciousness of wrongdoing, sort of alluding to what the government itself argued in Snyder. And that almost imports what we call a specific intent requirement, that the public official not only knows the facts that they did, but also knows that those facts, the actions that they took were wrongful, were illegal under the law.
I mean, the trial included 11 weeks of testimony. The jury heard from more than 60 witnesses, including Madigan. Was there enough evidence there for Madigan to be convicted, even using a jury instruction that requires specific intent?
Well, it's interesting because Judge Blakey actually said that. He said that in this case, bribery itself, especially bribery has now been defined by Snyder as in advance agreement between a public official and a private party, is inherently wrongful. And so almost suggesting that everybody knows that this is illegal to do, and so you don't have to have that specific intent requirement. The court also alluded to the fact that Madigan himself was trained as a lawyer, which kind of gave him also notice that this was wrong, what he was doing.
So does it seem like the Supreme Court is poised to take another step in a case like Madigan's?
According to Judge Blakey, no. He suggests that the law is clear in the Seventh Circuit on this issue. But clearly, Madigan is looking beyond the Seventh Circuit by hiring people that have advocated before the Supreme Court and successfully. So I would expect that their eyes are set on the Supreme Court and that they think this is a further avenue to try to narrow the scope of what they would consider prosecutorial overreach.
Let's just say that the Supreme Court reversed the bribery convictions. He was also convicted of conspiracy and wire fraud. Would those convictions hold and he'd still have to serve time?
That is possible. And the court did allude to the fact that he was also convicted of a Travel Act violation, which has as a predicate act state-level bribery laws. And so even if Madigan was to succeed ultimately in overturning his bribery convictions, that isn't the end of the story. He may end up still with other convictions at the end of the day.
And in the convictions of what are called the ComEd 4, the defendants who were convicted of bribery, conspiracy, and falsifying records in a scheme to illegally influence Madigan, an Illinois judge earlier this year threw out the bribery convictions there because of flawed jury instructions?
That's right. That trial had occurred before the Snyder case. And so when the court looked back with the benefit of now understanding what the Supreme Court had said about bribery, was concerned that the instructions were flawed. And so removed all of those substantive bribery convictions, but let stand the conspiracy conviction And that is a multi-object conspiracy, which involved both 666 bribery and these FCPA violations. And one possible avenue for appeal by the ComEd 4 is to suggest that because this was a general verdict, which did not specify which criminal object was proven under the conspiracy, that once the court threw out the bribery allegations, that it's not clear what the jury decided. Did they decide that there had been a conspiracy based on the bribery or on the FCPA violations? So I would expect the ComEd 4 to attack the conspiracy conviction as well.
And one of the defendants has hired Paul Clement, superstar conservative lawyer and Supreme Court litigator. Does a statement seem to indicate they're going to focus on the Trump administration's new stance on the FCPA?
It's interesting. I heard stories to suggest that the defendants in the ComEd 4 case actually had gone to the Justice Department to get them to reconsider these FCPA books and records violations based on recent guidance in which DOJ has been scaling it back its use of the Foreign Corrupt Practices Act. Basically, they don't want to prosecute what are otherwise considered routine violations, and they're focused more on transnational organized crime and other sorts of national security interests. And so at least what some reporters have suggested is that there had been some outreach with the Justice Department, but they weren't successful. But I would assume by the hiring of Paul Clement that the ComEd 4, or at least the former CEO, intend to try to pursue this all the way to the Supreme Court to suggest that the prosecutors here are also stretching the boundaries of the Foreign Corrupt Practices Act, which really was designed to attack and combat against bribery of foreign officials, not domestic concerns. And what the Justice Department has done in the ComEd 4 case was to bring these books and records violations to basically address purely domestic companies that were involved in purely domestic alleged bribery. I would expect that Mr. Clement would say that really stretches beyond the intended purposes of the Foreign Corrupt Practices Act.
Mark, you were the chief of the public corruption unit at the Detroit U.S. Attorney's Office. Can you describe how difficult it is now to bring these kinds of cases? What prosecutors have to consider before bringing a case?
Yeah, public corruption cases are intensely difficult to bring. That traditionally has been the elite office in any U.S. Attorney's office and consists of some of the stars of the office who have been there for a long time and know how to build a case. And the challenge of a corruption case is unlike let's say, a drug transaction where you know, for instance, that cocaine exchanging hands is illegal. In the case of public corruption, the thing that is being bargained for is an official act, which in and of itself is not illegal. And so you need to know more to understand why that transaction is illegal. And so you have to look at the intent of the parties. You've got to draw a lot of circumstantial evidence, either of consciousness of guilt because they're hiding the money, or having a wiretap so you can actually hear the words of the two parties transacting in these things. Maybe having an informant wearing a recording device. But because of the Supreme Court's ratcheting back of the corruption statutes, it is becoming increasingly difficult to try to prove these cases, especially with the use of consultants and other people that sort of insulate the public official from maybe the person that is paying the money. And so I think in the future, it's going to be harder and harder to bring these kind of cases. Added to that is the polarization of our country. I mean, right now, both political parties are making counter accusations against each other of the weaponization of the Department of Justice, that somehow that the Department of Justice is misusing its investigative and prosecutorial functions. That seeps into a jury pool, and it could have a spillover effect. In a criminal case, you've got to get 12 people that unanimously agree beyond a reasonable doubt that a crime has been committed. And can you get that today when there are a lot of skepticism about the motivations of the prosecutors? It remains to be seen.
And also the Trump administration has been cutting back on the people in the public corruption units, right?
Well, at least in the Department of Justice, in their public integrity section, there are fewer prosecutors, I'm told there. I don't know that that's impacted the U.S. Attorney's offices around the country, which really bring the bulk of the corruption cases.
This is a really fascinating area. Thanks so much for joining me, Mark. That's former federal prosecutor Mark Chutkow, a partner at Dykema Gossett.
Already they're saying he's a dictator. The place is going to hell, and we've got to stop it. So instead of saying he's a dictator, they should say we're going to join him and make Washington safe.
President Trump says he'll indefinitely extend the federal government's takeover of the Washington, D.C. Police Department past the 30 days allotted by law by proposing a law to Congress, or if necessary, by declaring an emergency. Trump also suggested that a D.C. crime bill would be a template for other cities.
And we're going to do something, and that's going to serve as a beacon for New York, Chicago, Los Angeles, and other places all over the country. Our whole country is going to be so different and so great. It's going to be clean and safe and beautiful.
My guest is Joshua Kastenberg, a professor at the University of New Mexico Law School and a former judge in the U.S. Air Force. We keep saying unprecedented, but in an unprecedented move, Trump deployed nearly 5,000 National Guard troops and Marines to Los Angeles in June. He's deployed about 8,500 active duty troops to the southern border, and now he's deploying 800 National Guard troops to D.C. And in all these situations, he said there was an emergency of some kind. Is he trying to expand the use of the military for domestic issues?
You can take each of those three instances, and there are three different legal analysis that you would have to do with each of them. But you could take each of those three instances, and you can come up with the conclusion, as I do, that he is trying to normalize the use of military force to coerce Americans, including their elected representatives, to get his way. This is the very thing that the framers of the Constitution warned of in terms of fears of standing armies. You can read that in the Federalist Papers. It's very clear that bright men like Thomas Jefferson and James Madison, John Adams were all opposed to the use of military force to police and corral the American people. They were fine with governors as commanders-in-chief of their militia, using the militia forces as a police power. And so they created a constitution that has a federal government that is a government of limited powers. And then you look at the 10th Amendment, you look at the militia clauses, and you can conclude from that governors have what's known as police powers, but the federal government does not. And what that means is that within those limited powers, the use of a military force to police, particularly in light of the 1878 Posse Comitatus Act, should only occur if there's an emergency from a foreign country or if there's an insurrection or a complete collapse of the civil government, meaning the courts aren't working, the police aren't working, and the people have nowhere to go. That's not what's happened in Los Angeles. It's not what's happened in Washington, D.C. And as for the border, the President of the United States has the authority to protect the national security of the country. And in theory, as long as Congress appropriates money, there's nothing inherently unconstitutional about using the military on the border. Creating military zones that are enlarged beyond the norm, that's kind of a gray area of the law. But I think the courts will probably rule in the favor of the administration on that one, and I could understand why. But if you couple that with what happens in Los Angeles and what's happening in Washington, D.C., then it becomes worrisome.
Explain why Washington, D.C. is different from L.A. or any other city.
So if you take Washington, D.C., it's not a state. Home rule was established by the Congress of the United States in 1973, so some 52 years ago. Washington, D.C. obtained a degree of home rule where they elect a mayor, and we have a very popular democratically elected mayor in Muriel Bowser. You have a democratically appointed chief of police. The people in Washington, D.C. are largely confident based on their voting patterns in both the mayor and the chief of police, and crime is going down. Now, the president is the commander-in-chief of the D.C. National Guard. He doesn't have to go through the governors to activate the D.C. National Guard. He can do that. The president, in theory, could run the police force from the Attorney General of the United States or the Homeland Security Department or from the White House itself for abbreviated periods of time, in theory, if there's an emergency or a need to do so. There is no spike in crime or, vast amounts of lawlessness of a violent nature in Washington, D.C. that would justify this. And it'll fall to the courts to make a determination as to whether there even has to be an emergency to justify what the president is doing in this or not. But the rhetoric behind it is troubling because it reminds me of something that, the Supreme Court decided in a very famous and important case on presidential authority known as the Youngstown Sheet and Tube case. And it has to do with Harry Truman ordering the seizure of steel mills in the United States during the Korean War when Congress didn't act to authorize it. And Justice William O. Douglas said, if a president can routinely declare when an emergency exists without the oversight of Congress or without a real emergency that's apparent to the people of the United States and the Congress of the United States, then we'll never hear the end of presidents declaring one emergency after another to get their way and do an end run on the law. And I think that's what's happening with Washington, D.C. right now. In point of fact, the biggest crime wave in Washington, D.C. that we've seen in the last couple of decades occurred on January the 6th, 2021. And yet the president did not exercise his authority as commander-in-chief to call out the guard or federalize the police at that moment. So why is he doing that? Well, probably to suit political ends, to appear as a strong man. And it's to push the boundaries of the law, keeping in mind that he does have certain authorities to do it that he does not have in places like Los Angeles, where the 10th Amendment reserves quite a bit of power to the state governments.
Is LA a test case? Because about a month ago, Trump, while in the Oval Office, talked about taking action if Zohran Mamdani was elected as mayor of New York.
I used to say we will not ever be a socialist country, right? Well, I'll say it again. We're not going to have, if a communist gets elected to run New York, it can never be the same, but we have tremendous power at the White House to run places when we have to. We could run D.C.
Here's the problem with that rhetoric, and it's the same problem that, Homeland Security Secretary Noem said, and I'm paraphrasing her, about why the Guard is going into Los Angeles. She said it's there basically to affect political change. And that's, Trump's threat in regard to New York. I can't help but think it's more than a coincidence that at the very time a United States District Court judge in California is ruling on the constitutionality of Trump federalizing the National Guard without going through the governor first and perhaps in violation of the Posse Comitatus Act, that the National Guard is being federalized in Washington, D.C. It's as if to tell the judge in California, you don't matter. I'm the boss here. And I want to hearken back on these threats to a time that we don't really study much anymore in our constitutional law classes in law school or even in high school history, and why the framers of the Constitution constructed the document as they did and what their fear of standing armies was. They were very well aware that in Britain, 100 or so years earlier, at the time of Oliver Cromwell, that when Cromwell's forces overthrew, King Charles, and there were important votes being taken in Parliament about what kind of government to have, what to do with to depose King Charles, the army of Oliver Cromwell, parts of it, marched into Parliament and kept those middle-of-the-road members of Parliament from voting on those key issues. And it was called Pride's Purge. It's named after Major Pride, who led Cromwell's soldiers to stop Parliament from voting. Shortly after that, the government of Oliver Cromwell was dubbed the reign of the major generals. It was, by all instances, a military state, and it ignored the Magna Carta, other documents of important, basis of liberty, which we cherish today, particularly the Magna Carta. So when Madison and Jefferson and Adams and the other bright minds that led the United States through the War of Independence constructed the document after, it was clear the Articles of Confederation had failed the people of the United States, They constructed a document that tried to rein in as much military authority as possible from the president by keeping the army very, very small and out on the borders and warning about the fear of standing armies to never allow that to happen again. Not in this country. And you can read letters from Adams and Jefferson and Madison and the men in the states that voted to ratify the Constitution on that point. That was one of the most important features in creating the Constitution of the United States. And it seems to me that if you take a look at what, Secretary Noem said about calling up forces in Los Angeles, or Trump's threats about, taking over the city of New York, it's the very type of, Cromwellian dictatorial move that was assured by the framers of the Constitution would not happen in this country. When I've made this comment on the local news, I'll occasionally get hate mail like, what are you, a Marxist? Are you anti-American? And my answer to that is no. I am simply reiterating what those freedom fighters, Jefferson, Adams, Madison, warned about in creating the document. It's not a radical idea to speak of the fear of standing armies. To the contrary, it's an idea that goes into the heart of what makes American liberty exceptional. It is that we do not govern by the military. We do not use the military to corral the political behavior, the votes, the abilities of democratically elected people we disagree with from doing what the voters sent them to office to do.
So now he said today that he's going to be asking for extensions on the 30 days. And he said, I think the Republicans in Congress will approve this pretty much unanimously. And he also said he wants a crime bill that will initially apply to D.C., but then to other cities.
What I would say about that is, if Republicans were to listen, if I were to be advising them, I would remind them that any law they pass today can be used by any future president with the flexibility that President Trump seeks. You would only vote for this kind of a law if you believe that in the decades ahead, you will only have Republicans like President Trump with his ideology sitting in the White House, because otherwise these kind of laws are disastrous for a democratic society that permits people to freely vote for the changes or the continuance of government as they see fit. And so, I go back to the House Un-American Activities example. It comes up under, Roosevelt's administration during the New Deal, and it's designed to focus on Nazi influences in the United States, and the Democrats gleefully pass it. But within a half of a decade of its passage, it's being turned on liberal Americans who are accused of communist sympathies and communist ties. And you don't vote for the very thing that Trump is asking for unless you are somehow absolutely assured through your magic 8-ball that you will always have your guy sitting in the White House. And you're not. You can't have that kind of assurance.
Also, the Washington Post is reporting, according to internal Pentagon documents reviewed by them, that the Trump administration is evaluating plans that would establish a, quote, domestic civil disturbance quick reaction force composed of 600 National Guard troops to be on standby at all times so they can be deployed in as little as an hour to American cities facing protests or other unrest.
I have a suspicion that those documents may have been deliberately leaked for two reasons. One is this is not the first time a presidential administration has had internal documents that speak to this issue. That happened in the Nixon administration. It happened in the Johnson administration. Neither presidency actually had those plans in effect when they came in. But I think that they're probably hoping that the media makes an error and says, this is unprecedented. It's never happened before. Having said that, we need to take cognizance and embrace this concept of the lessons of history. It's perfectly fine to have a military force that's trained to respond to national emergencies, natural disasters and foreign invasion, cyber attacks, and things like that. If we don't, then we're not having the military that we need. But having said that, if the Republicans in Congress rubber stamp this type of thing by funding it, by voting for extensions of presidential authority and undermining D.C. home rule, then essentially what they're doing is they're taking a stepstone back to that, place that the framers of the Constitution warned we should never go. And I would hope that enough people on both sides of the aisle, on ideologies ranging from libertarianism to the far left, they take a step back and they say, no, you can't do this. This is not why we elected you into the White House. This is not why we elected you to Congress. You cannot just willy-nilly say there's an emergency here and there's an emergency there, and I'm going to enforce my will through the presence of the military.
Well, I think it's going to be important to see how Judge Breyer rules in the trial over the Trump administration deploying the National Guard and Marines to Los Angeles. Thanks so much, Josh. That's Professor Joshua Kastenberg of the University of New Mexico Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.